Thank you for joining, everyone. I'm Adele, and I'm a specialist trainer here at Altron Healthtech with 8 years of training experience in software and soft skill products, which includes practice management applications, a medical receptionist course, as well as medical claim switching. Today, I will be offering information about POPIA and how a medical practice can align current processes with this data privacy law. I just want to cover a few housekeeping rules. So during the webinar, you can use the chat button to the top right of your screen to ask questions. All previous questions from staff and practices that we have received thus far will be addressed during the presentation. If there are any unanswered or additional questions, those will be compiled and answered in a blog article and sent to you by Healthtech. Our risk and compliance specialist, Annalise de Bruin, will be the moderator of today's webinar and will pass on the published questions after the webinar for the blog article. Remember, there's no such thing as a silly question, so please ask away. Now we've covered housekeeping, I'll quickly run through the agenda for today. You'll see today I'll be discussing 7 topics. Firstly, collection of personal information in healthcare. I will present you with a comparison of the old processes of the HPCSA versus the new rules of POPIA. We'll explain POPIA. What does this act ensure with regards to your conduct when you collect or process or store or share personal information? Also, a few definitions in relation to healthcare practice. So when we speak about a data subject or an operator or a responsible party, who are they really? So in effect, who does POPIA affect? Also, I will give examples of what an individual's personal data really is. Processing of personal information in healthcare. In this topic, I'll discuss 6 rules that must apply when personal information is processed. I'll offer insight on the Hippocratic Oath on how that relates to ethics and ties into the POPIA Act. I'll give you an extraction from the Act, section 26 to 33 to be specific, and this information relates directly to the medical industry, but also to a few other sectors. Then how Altron Healthtech processes your data. I'll discuss 3 areas specifically. Firstly, systems, our software products and switch, and how does Healthtech ensure that your data is protected. Our contact center, how do the consultants apply the rules when receiving phone calls from our practices? And then Altron's direct marketing, which includes methods to protect your rights. Collecting personal information and how you should give consent. For example, consent forms, and then also the criteria the consent needs to meet, and we will look at 3 points specifically. Lastly, security, storage, and destruction of data, how to ensure that the practice complies to the Act, some destruction methods of your data, for instance, your paperwork or your electronic data, the importance of including POPIA protocol in your standard operating procedures, and what will the practice need to update regularly, and also what to do if there is a data breach at the practice. So first, the collection of personal information in healthcare, the old processes versus the new rules. We can see in this puzzle image, it displays how the HPCSA had driven and directed certain protocol regarding protection of information versus the new rules directed by the POPIA Act. So in the past, you and your staff gathered and generated personal patient information. You took consent from the patient, you stored and processed the patient information, for instance, on your software as directed by the various Health Professions Councils of South Africa booklets 1 to 5, 7 and 9 specifically. The new rules to healthcare data collection via POPIA. So POPIA codifies personal information and the access to it, and thus brings a new facet to record keeping. You need to keep the following essential topics in mind, and we will discuss during the webinar. Firstly, security, the security and safeguarding of personal information and also our products. Consent, the process of consent and the methods of getting consent or permission. Training your staff, bringing everyone up to speed with the rules of the Act and keeping records thereof. Then any data breaches, I'll be offering information on what to do if there is a data breach, and then alignment of POPIA and promotion of access to Information Act manuals. Let's explain POPIA. So what does this act ensure with regards to your conduct when you collect or process, store or share personal information? In your practice, as we know, you collect patient information. What do you do with it? You open an account on your software, your PMA as we refer to it, your practice management application. You maybe open a yellow file and you store it in a filing cabinet, or you share with a scheme or a lab, empath, right? So in simple terms, the purpose of the POPIA Act is to ensure that all individuals carrying on a trade, business or profession, partnership, juristic persons and public bodies in South Africa conduct themselves in a responsible manner when they collect, process, store or share personal information. The Act holds such individuals and entities accountable when they collect, process, store and share another entity's or individual's personal information should it be abused or compromised in any way. Example, a patient's personal information is compromised when you share his details out loud when speaking on the phone, or if it's visible to other patients, like on a day register. So you could ask yourself, would it be acceptable to you if you knew your personal information was visible to other patients or visitors at the service provider you visit? The POPIA legislation considers personal information to be private and precious goods and aims to bestow upon the owner of the personal information, which is you and me, certain rights of protection and also the ability to exercise control over the following: when and how the owner chooses to share his personal information. He must give consent. The type and extent of information it chooses to share, so there should be valid reasons why it should be shared. Transparency and accountability on how its data will be used, so it should really be used and limited only for the purpose that the consent was given for. Notification if and when the personal information is compromised, who has access to my information, how and where your information is processed, so it should be protected from theft or being compromised. And then also the data subject or the patient can expect continued accuracy of the information, so it should always be captured correctly and maintained correctly. Switch also includes a tool, for instance, in your software program called MSV or Membership Status Validation that you can use to verify patient information as it is at scheme level and therefore update your patient information. POPIA definitions in relation to healthcare practice. For instance, so who does POPIA affect? If we speak about a data subject or an operator or responsible party, who are we referring to? I'll also give a few examples of what an individual's personal data really is. Starting with the responsible party. You, the practice, are the responsible party of your patient's information as you determine the purpose of and means for processing the personal information. The data subject, that could be the patient, defined as the person to whom the personal information belongs to. Another example, as staff of Altron Healthtech, I and everybody working with me, we are all data subjects because we also share personal information with the company during our recruitment phase. The operator, who's the operator? Anyone who processes information on the practice's behalf, but is not directly under your authority is referred to as the operator. The operator can be a person or company who processes personal information for the responsible party in terms of a contract or a mandate. Example, Altron Healthtech's MediServe acts as a bureau partner to individual doctors or practices who can be referred to as the responsible party. A doctor will collect patient information for billing purposes and for the sake of the consultation. A MediServe clerk will then process the information on behalf of the doctor or the practice, making MediServe the operator. Remember, personal information is private and precious goods. What is the definition of, or who is the definition of processing of personal information? Processing is anything you do with the personal information. Process is a verb, so it's a do word. So what do you do with the personal information? It could be collecting or opening an account or filing or sharing So anything that you do with the personal information, including collection, it could be via paper forms or online forms, storage in your yellow files or in electronic health record systems, modifications, sharing, for instance, with other medical professions, destruction, etc. Personal information is any form of information which makes an individual identifiable. It includes, amongst many other examples, the identity and or passport number, the date of birth, age, gender, race, and ethnic origin, any contact numbers, phone or landline numbers, email addresses and physical addresses, photos, voice recordings, video footage like the CCTV cameras, biometric data, private correspondence, religious or philosophical beliefs, including personal and political opinions, employment history, salary information, financial and education information, physical and mental health information, including medical history, blood type, details of sex life. Processing of personal information in healthcare. During this topic, I'll discuss 6 rules that must apply when the practice processes personal information. And remember, process is your do. I'll also give you insight on the Hippocratic Oath and how that relates to ethics, and then again ties into the POPIA Act. Also, extraction from the Act itself, section 26 to 33 to be more specific. This information relates directly to the medical industry, but also to a few other sectors. Personal information may be processed if one or more of the following applies. The data subject, the person, of course, who the data belongs to, should give consent or permission. The data should be necessary for performance of a contract. If the law imposes that the responsible party, in this case, say the practice, is obliged to process or share personal information of a data subject, who's the patient. If the processing protects the legitimate interest of the data subject. If there is a legitimate interest of the responsible party, the practice, or third party, which could be the scheme or bureau, to whom the personal information was supplied, and if it's necessary for the performance of a public law duty by a public body. An example, implementation of prison sentences or detention measures. The Hippocratic Oath is the oath of medical profession that all practitioners swear to in a court of law. So ethics are defined as moral principles. Within the healthcare field, there are standards which must be met and maintained in regard to ethics. So let's look at the words moral principles. Moral means relating to beliefs about what is right or wrong, of course, and a principle is a general belief that you have about the way you should behave, which influences your behavior. So the 3 ethical considerations that need to be taken into account and relates directly to POPIA's directives are respect for patient autonomy, informed consent, so autonomy, the right or the condition of self-government. Also probity, the quality of having strong moral principles, honesty and decency, and respect for patient confidentiality. Also in a moment, when I will discuss the collection of personal information and how to get consent, I will elaborate on how it should be tied into this first topic of informed consent, which is an ethical consideration which falls under the Hippocratic Oath. This is our extraction from the Act, section 26 to 33 to be specific. So there's a general prohibition on processing personal information concerning a data subject's, which is the patient's, health or sex life. But in terms of section 32.1, this does not apply to processing by medical professionals, healthcare institutions, or facilities or social services if the processing is really necessary for the proper treatment and care of the data subject. A responsible party that is permitted to process information concerning a data subject's health or sex life and is not subject to an obligation of confidentiality by virtue of office, profession, or legal provision must treat the information as confidential unless the responsible party is required by law or in connection with their duties to communicate the information to other parties who are authorized to process such information in accordance with Section 32.1. So really, in short, a practice is not prohibited by law to collect, process, share personal information of a patient, but must be responsible with the information and comply to the rules laid out as it is in the Act. So 5 entities who is not prohibited by law to process personal information, and also the reasons why they may collect personal information, are the following: medical professionals, healthcare facilities, or social services. Why should they collect? Why would they not be prohibited? Well, it's for the proper treatment and care of the data subject, the patient, or for the administration of the institution of professional practice, or for medical and related professions, as well as healthcare facilities, are exempt from the prohibition on collecting and collating information pertaining to a patient's health, sex, and biometric data. Insurance companies, medical schemes, administrators, and managed care organizations. The prohibition on processing personal information does not apply to these groups if such processing is necessary for assessing the risk to be insured or covered by the scheme and the data subject has not objected, for the performance of an insurance or medical scheme agreement, or the enforcement of any contractual rights and obligations. Public bodies. For the implementation of prison sentences or detention measures. Fourthly, schools, on public or private bodies managing the care of a child, to provide special support for pupils in connection with their health and sex life and performance of lawful duties. Lastly, administrative bodies, pension funds, employers or institutions working for them, implementation of legal provisions, pension regulations, or collective agreement affecting the health or sex life of the data subject, or support in connection with sickness or work capacity. So that is why these entities are not prohibited. Moving on to our 5th topic, how does Altron Healthtech processes your data? Most of the questions received thus far from practices will be answered in this section. I will cover 3 areas: systems, our contact center, and also Altron's direct marketing, and how we go about to ensure your information is kept private. Starting off with our systems. So Altron Healthtech is a division of Altron, and as such is guided by Altron's POPIA and privacy policy in compliance to the laws of the Republic of South Africa. We respect all our customers and we value your information. We do not provide your personal information or that of your patients to unaffiliated third parties. We don't sell, rent, distribute, or otherwise make such personal information commercially available to any third party without your consent or that of your patient if not in compliance with POPIA. You may at any time request that we share the information we collect about you. However, we do have processes in place to ensure that this is done within reason and in compliance with POPIA. Our security and safeguards methods to secure our products. Let's look at our online products like Elixir Live, Health One, and MediSwitch. All personal information in these products are encrypted in transit and at rest. Transit means when Switch moves your data to the medical scheme. At rest means the information that's in your software. Only authorized staff have access to these systems and the data they contain. Organizational security controls are in place to prevent unauthorized access to information. For instance, physical access controls, firewalls, username and password logins, backups, and disaster recovery processes. Other products like ME Plus and Elixir Classic, we do not have access to the data in these systems. Physical access to the data and encryption at rest is the responsibility of the practice. Access to the data in these systems during a support call out always accompanies permission from the practice. Data in transit to the MediSwitch switch-on service is encrypted. Practices can contact one of our account managers to obtain a data operator agreement for MediMass and MediSwitch to protect the personal information that they have access to. The process really, in fact, starts with a product sale. So we have a form called One Contract. That is really the only form from the practice that the practice will need to sign. Altron is 100% compliant in their conduct towards practices. All our products ensure POPIA compliance via the implementation of mandatory access passwords, for instance, encryption of statements that you might want to send from your software via email. A practice can encrypt a statement by using an ID number of an account holder, a membership number, or practice number as example. Practices must therefore process the data subject's detail 100% correctly in their software program. Remember to use your membership status validation tool. All data in the product is protected. You can say encrypted by your access password for Classic and ME+. Elixir Live is hosted in the cloud, which is also protected by security features. Our contact center. Our contact center agents will ask security questions to protect your practice and ensure safety of data. A minimum of 3 questions relating to your practice will be asked. Should any answer differ from what we have on our system, more questions may be asked or be referred to our compliance department before we can assist you. Please ensure that your personnel that are authorized to contact us on behalf of your practice do have relevant answers to help our contact center ensure speed of service and great customer service. Our direct marketing and sales communication. We may send you direct marketing communications about our solutions, our products and services, and you can choose whether you wish to receive marketing communications from Altron Healthtech and the rest of the Altron operations by email, SMS, or other electronic communications. You may also opt out of receiving marketing materials from us at any time and manage your communication preferences by emailing us on healthtech.info@altron.com. If you opt out of receiving marketing-related communications from us, we may still send you administrative messages as part of your ongoing use of our products, solutions, and services, which you will be unable to opt out of. All our direct marketing messages carry standard opt-out links and an opportunity for you to update your opt-in preferences for the below. Altron Healthtech product news and updates, including events, launches, etc. Healthcare industry news and updates, scheme updates, for instance, via SMS or WhatsApp. It's a very good feature. I know during my experience of training, this was something that the delegates really liked, the updates via WhatsApp. Altron Healthtech quarterly newsletters and blogs, and Altron group messages. So to conclude, what we do, our marketing department, we do request consent from our new customers, your opt-in. We get existing customer consent. We inform the data subject what their info is going to be used for. We always offer a way out, that would be our opt-out, and we keep records of all our opt-ins. Collecting personal information and how you at the practice should get consent. Very important topic. In this topic specifically, I'll cover how would you get consent, for instance, consent forms, and also criteria the consent needs to meet. And we will look at 3 points. Both existing and new patients must be asked to sign a consent form. It needs to be voluntary, of course, specific and informed, granting permission for their personal information to be processed and used for follow-up reminders. So the information in this slide particularly ties into the information I gave you earlier about the Hippocratic Oath and how that relates to ethics. Remember, our ethical considerations was informed consent, probity, and respect for patient confidentiality. So a patient's right to autonomy, and again, I want to explain the word autonomy. An individual's autonomy is an idea that is generally understood to refer to the capacity to one's own person to be independent. So a patient's right to autonomy is enshrined in the Constitution, and it is an ideal that carries the force of law. Informed consent relates to a person's right to human dignity and autonomy. So mutual trust and understanding between the doctor and the patient is extremely important. A patient must always be given enough information, also in a language that he or she completely understands, to make an informed decision. So, to be considered valid, consent to a medical intervention must meet 3 criteria. Firstly, the information. The patient must be informed about the material risks as well as benefits of the proposed intervention. The capacity. The patient must be capable of taking in the information, understanding it, weighing it in a balance, and arriving at a decision. Lastly, non-coercion. The patient must be free of undue pressure or coercion in making his or her decision. Remember, if the doctor discusses openly with their patients what is and what's not possible, they will have a more realistic expectation and less likely to feel disappointed when an otherwise successful treatment doesn't bring about the same hoped for improvement that they might have seen in somebody else. Where the healthcare provider cannot obtain informed consent personally, the task may be delegated to a person who is suitably educated, trained, and qualified. A nice example is a nurse. A person who has sufficient knowledge of the proposed treatment and can answer questions, of course, and an understanding of the possible risk involved. A person who is aware of the HPCSA's rules and regulations related to consent and who acts in accordance with these guidelines. Where a patient cannot give consent, the following applies. So when could a patient typically maybe not give consent? Well, if he was in a serious accident and is unconscious. Can treatment continue? Yes. Treatment may continue without consent, but only in a medical emergency. How do you know it's an emergency? How do you classify it as an emergency? This emergency is classified as life-threatening without immediate intervention, and therefore treatment would be required. However, the provided treatment must be limited to what is required to save the life or to avoid significant health deterioration. After the stabilization and emergency, and as soon as the patient is able to understand and has recovered sufficiently, the healthcare practitioner must inform the patient of what has been done. So if we just look at this specific topic, if the patient is bleeding and his life could be saved by only stopping the bleeding, for instance, and not amputating the leg, then only that must be done. So really only the life should be saved during this emergency. So Section 34 prohibits the processing of personal information concerning a child, unless there is general authorization to do so in terms of Section 35. So the personal information has deliberately been made public by the child with the consent of a competent person. So that is when it can be made public. It is for historical, statistical, or research purposes to the extent that the purpose serves a public interest, or it appears to be impossible or would involve a disproportionate effect to ask for consent. If it carries out with the prior consent of a competent person, and if it is necessary to comply with an obligation of international public law. Last but not least, this brings us to security storage and destruction of your data. During this topic, I will tell you how to ensure that the practice complies to the Act, some important destruction methods of data, for instance, your paperwork or your electronic data. You need to stay informed. You could also include your POPIA protocol in your standard operating procedures, what needs to be updated regularly at the practice, and also what to do if there is a data breach. So how to ensure that the practice complies to the Act. As healthcare professionals, you are trusted by your patients to safeguard not only their health, but remember also their privacy. Any personal information you hold must be protected from loss, damage, unauthorized extraction, and unlawful access. Your practice should implement appropriate, reasonable, technical, and organizational measures to ensure this. Remember, you and your staff have an obligation to confidentiality to your patients in terms of a written agreement as referred to below, and thus qualify to collect and store their personal patient information. It is your obligation to prevent loss, unauthorized access, or unauthorized destruction of personal information or processed information. I mentioned earlier, a patient's personal information is not protected if it is visible to any other patient at the practice. Risk assessments must be regularly carried out and documented no matter the size of the practice. Operators, they should ensure that your contracts with outsourced companies, including practice management software companies like Altron, billing bureaus, practice accountants, align with the tenets of POPIA. So these data operators process your patient's personal information, and your contracts with them will be useful when protecting you should they experience a data breach outside of your control. Your staff have to have up-to-date written agreements for the adherence to POPIA and security of information with your staff. Encourage and ensure your staff that they attend seminars or training about POPIA and their responsibilities towards safeguarding patient data. Always record the dates and attendances of training in case of an inspection or data breach. Altron Healthtech also offers a receptionist workshop or a one-day course that provides aspects of POPIA. More information about this course can be found on healthtech.training@altron.com. Let's talk about the destruction methods of data, like your paperwork and electronic data. Personal medical data must also be destroyed after there is no further use for it, unless there is a medical reason to maintain it on file for future patient care in complicated cases. Practices should refer to the HPCSA's guidelines on record keeping, booklet 9, for the time periods to store health records. A few examples. Generally, medical records are kept anywhere from 5 to 10 years after a patient's latest treatment, discharge, or death. For mentally incompetent patients, the record should be kept for the duration of the patient's lifetime. For chronic illnesses, for instance, like cancer, 25 years. And then also certain health conditions take a long period to manifest themselves, like asbestosis. And records of patients who may have been exposed to such conditions should be kept for a sufficient period of time. The HPCSA recommends not less than 25 years. An efficient records management system should include arrangements for archiving and destroying dormant records in order to make space available for new records, particularly in the case of paper records. Records held electronically are covered by the Electronic Communications and Transaction Act, which specifies that personal information must be deleted or destroyed when it becomes obsolete. If records are to be destroyed, paper records should be shredded or incinerated. So medical officers must ensure paper and electronic records are destroyed by a method that provides for no possibility that the protected health information can be reconstructed. I should not be able to take out 4 pieces or 6 or 8 pieces of paper from the dustbin and put them together and read the information on it. Common destruction methods are burning, shredding, pulping, pulverizing for paper records. CDs, DVDs, hard disks, and other forms of electronics storage should be overwritten with random data or physically destroyed. Be wary of selling or donating your second-hand computers. Remember, deleted information can often still be recovered from a computer's hard drive. Also, you should keep a register of all healthcare records that have been destroyed or otherwise disposed of. The register should include the reference number, if there are any, the patient's name, address, and date of birth, the start and end dates of the record's contents, the date of disposal, and the name and signature of the person carrying out or arranging for the disposal. Let's look at your protocols. Stay informed at the practice. Remember, you and your staff members need to establish a POPIA protocol and standard operating procedures for compliance to the Act. Give you a few tips. If you have a large staff, create teams and assign roles on POPIA governance. Also through your SOPs, your standard operating procedures, you can set up some steps on how data is collected, stored, and shared. A new employee, for instance, can just read through the SOP and immediately be able to pick up how the standard operating procedures should be executed. Assign responsibilities for each process. So you as the responsible party, the practice, have an obligation to identify internal and external risks to personal information, establish and maintain appropriate safeguards, and regularly verify that these safeguards are effectively implemented and regularly updated. See to it that you get regular training on POPIA and data management and a frequent POPIA compliance assessment. Where are the gaps? Where are the risks? What is it the practice that needs to be improved? So try and identify those. Align your policies and also ensure that they are enforceable. Therefore, include disciplinary action for non-compliance. Update assurance request and your patient consent forms as well. So what is it that needs to be updated regularly at your practice? Right. Update your computers and software regularly to reduce data breaches. Digitize your patient's records and store hard copies in rooms or cabinets that are lockable. But also, if you do not use a cloud-based product like Elixir Live, I'd advise that you even store a hard copy of your records off-site as well, for in case of a fire. Ensure security updates on routers and other devices are done regularly. Remember to never share your Wi-Fi password with non-staff members. Password protect your emails as far as possible. Always check recipients before you send an email, and where possible, encrypt any attachments that may carry personal information. Ensure that your website is compliant by having your privacy policy and POPIA manual where your visitors can find it. What to do if there is a breach of security? Data breaches unfortunately may happen, and it is therefore important to be well prepared for a data breach. When and if it happens, have a written data breach policy directive, educate your employees on the directive, and review it from time to time. So some essential elements of a data breach response policy could be the following. Remember, this must be a written document, easily accessible by the staff, and should explain the following. The urgency of the response required to a data breach. What security was breached and what data was compromised. The people to whom the breach must be reported internally, like the information officer. Whose responsibility is it to report to the regulator? Where there are reasonable grounds to believe that the privacy of personal patient information has been compromised, you must notify the regulator as soon as possible. Subject to Section 22.3 of POPIA, you must notify the patient unless the identity of the patient is not known. The regulator may direct that you publicize the matter if it has reasonable grounds to believe that such publicity would in fact protect a compromised party. Also, is responsible to take immediate steps to secure the data from further compromise. How are you going to assess the breach of security? And what future preventative measures will be implemented? Lastly, I'd like to offer you some links of Altron POPIA and private policy. Our Altron Information Officer, Shane Mann, you can find his information on this page as well. Then also information of our Deputy Information Officer at Altron Healthtech, Wayne Botha, a link to medico-legal news, records held and processed by Altron Healthtech. Remember, the information we collect from our customers is defined in our privacy policy. In terms of the online services that we provide, we process or store the demographic, medical, and clinical information of patients captured onto the systems, as well as user credentials for practice staff to access these systems. If you needed to request records or make a correction or deletion, or copies, maybe want copies of the information we have, you can contact healthtech.admin@altron.com and cchealthtech.info@altron.com. Also 2 links to articles of POPIA Healthcare News and POPIA. That brings me to the end of the slide. Thank you for your time. Thank you for spending your time with me, everyone. And just a reminder that we note the questions and we will address them all in the blog post.